Breaking news in the Karen Read case. The highest court in Massachusetts denying an effort by the defense here to have 2 of the 3 charges against her dropped. This is now setting the stage, of course, for the retrial in just a few months. Thanks for being with us today at 11. I'm Melody Mendez.
And I'm Lauren Melendez. So Read's first trial for the death of her boyfriend, John O'Keefe, as we know, ended in a mistrial. But her defense team claimed that she would have been acquitted on some of those charges.
So NBC 10 Boston's John Maroney is live outside the State Supreme Judicial Court in Boston with the breaking details. All right, John, what can you tell us?
Melody and Lauren, really not a huge surprise. The SJC has decided that the charges against Karen Read will not be dismissed, instead siding with the judge in the case. Read, of course, is accused of killing her boyfriend, John O'Keefe, hitting him with her SUV and leaving him to die in a blizzard. Her first trial ended in a mistrial last summer. At the time, jurors told Judge Beverly Cannoni they couldn't reach a verdict after considering charges of second-degree murder, leaving the scene of an accident after death, and manslaughter. Now, subsequent to the mistrial, the defense says a handful of jurors came to them and said the jury had actually reached not guilty verdicts with regards to the second-degree murder charge and leaving the scene of an accident. The defense argued that trying Read on those charges again would amount to double jeopardy. It asked the SJC to order the judge to interview the jurors, something she refused to do. The defense also criticized her for not giving them an opportunity to properly object to that mistrial and not giving the jury proper instructions regarding the verdicts. The state's highest court rejected all of those arguments. In its ruling, the court concluded the trial judge correctly denied the defendant's motion to dismiss and request for a post-juror trial juror inquiry. The case is remanded to the county court for entry of a judgment denying the defendant's petition for relief. Now, both sides, they are expected back in court on February 18th. Karen Read's retrial, second trial, is still scheduled for April 1st. Coming up at 4 o'clock, we'll have more reaction. Live in Boston, John Maroney, NBC 10 Boston.
John, thank you so much. I mean, of course, after this, there's just a lot to still break down about this ruling.
So joining us now is NBC 10 Boston legal analyst Michael Coyne. Michael, thanks for being with us. Let's dive right in. First, were you surprised by this ruling?
No, I don't think there's any surprises here. It's consistent with centuries of Massachusetts law. It would have been the real exception if the court decided to do something other than allow the 3 charges to go forward in April.
Where do we go from here, Michael? I mean, how likely is it that Karen Read's defense escalates this appeal?
I think it's not that likely. I mean, they always have an avenue to try and make some type of argument that the double jeopardy clause is impacted so they can go to federal court. But their efforts would be better spent actually getting ready for a trial in April, because you still face a number of very serious charges here, as the court laid out. The first-degree murder charge carries with it a long sentence. All of them carry with it some level of mandatory sentencing.
So what do you make of the argument here that the Judge Cannoni, should have polled the jury, should have basically asked each juror to confirm their conclusions about each count, because then she would have known that there was unanimous verdicts reached on 2 of those counts?
Well, she may have known, Melody. That's not necessarily true. The fact is that the court has a delicate balance, and the Supreme Court made clear here that you don't want to coerce jurors who have a good faith belief in a decision one way or the other to change that deeply held belief because they feel intimidated or coerced by the judge. And so the court made clear in its decision today that the trial court judge has a great deal of discretion in trying to determine whether there's a verdict that is heartfelt and legitimate. There was no verdict rendered in open court, and that's consistent with the law in the Commonwealth of Massachusetts, that then that verdict is, in fact, a non-verdict, and double jeopardy does not bar a retrial.
And it's such an important nuance that you specify there for everyone watching at home who thinks, well, that seems so simple. It's not really. No. Michael, does this have any impact whatsoever on the retrial as we move forward?
I don't think it has a significant impact either way. I don't see that it's a first-degree murder case. So even if the court had thrown that out, which they have not, that really doesn't change the dynamic. At the end of the day, what you've got is a driving under the influence, homicide, serious bodily injury case. Those cases are tried in the Commonwealth of Massachusetts virtually every day. And that's what this case will likely focus on. I don't see it as being a first-degree murder case. And the only thing that might change is it might mean that you take a little harder look at whether there's some type of plea arrangement here to avoid the 15 or 20 years in prison that a first-degree murder conviction would require.
To be honest, in all of our coverage of this case, a plea agreement has not popped into my mind recently. Do you even think there's a chance that we see that?
Well, there's always a chance of anything. And in this case, especially, as we all know, with all the twists and turns. I think it's highly unlikely. But, you know, never say never, you learn ultimately. If one were facing that type of prolonged prison term, they would have to take a serious look at any type of arrangement that would mean that you either could avoid prison completely or a very short stay. That would be something that I think most people would at least consider, even if it's a very, very long shot in this case.
All right, NBC 10 Boston legal analyst Michael Coyne, thank you, my friend. We appreciate it.
Always.